Great. Thank you, TJ. We will. So welcome, everybody. We are very thrilled to see a large crowd joining us today for this very interesting panel. As you know, the topic is the clash, contract terms versus applicable law. Thank you so much to Eduardo Zuleta and to the organizers for putting this together and for the very kind invitation to be joining you today as moderator. My name is Laura Sinisterra. I'm a senior associate at Double Voice, and I am delighted to be joining you today together with an amazing group of panelists. As you will have seen from the program, we will have a conversation today about what happens when parties draft a contract following the language and terms of New York law, but then apply a different law, sometimes from an entirely different legal system. This situation gives rise to complex questions of how to interpret and apply the law to the parties' contracts. And we will be dealing with those questions today. You will all see a function for a Q&A at the bottom of your screens. Please do feel free to send any questions our way, as we have sort of allocated 10 minutes at the end of the presentation for Q&A. Let me begin by again introducing our wonderful panelists today. Julie Bedard, most of them don't really need any introductions, but Julie is the head of Skadden's International Litigation and Arbitration Group for the Americas. She is trained both in civil and common law and has a doctorate in conflict of laws. She is a member of the Court of Arbitration of the SIAC and regularly acts as arbitrator, very impressively, in English, French, Spanish, and Portuguese language cases. And Julie is the immediate past co-chair of the Arbitration Committee of the IBA. We also have with us Galena Galena is a leading arbitration practitioner with almost 20 years of experience. She has served as an arbitrator in cases conducted under most institutional rules. She is a member of the ICC International Court of Arbitration, as well as of the Finnish Arbitration Institute and the Georgian International Arbitration Center. She is also a professor at the University of Versailles in France and Latvia, her home jurisdiction. Galena founded her own firm in 2019 and is based in Paris. We also have with us Brian King. Brian is an adjunct professor and distinguished practitioner in residence at NYU School of Law, as well as an arbitrator member of Chambers 3 at Verulam Buildings in London. He practices as an independent arbitrator in substantial commercial and investment disputes. Prior to commencing his solo practice in January 2019, Brian was a senior partner in the International Arbitration Group at Freshfields, based in Europe, and then from 2007 in New York. And last but definitely not least, Alfredo Bullard. Alfredo is a leading practitioner with particular expertise in areas of international trade and arbitration, competition law, and economic regulation. Alfredo has served as arbitrator in more than 200 cases and is currently a member of the ICC Court of Arbitration. He previously served as president of the Technical Commission of the Peruvian Ministry of Justice and led the review and amendments of Peru's national arbitration law. So we will begin our conversation with Brian. Brian, let's begin by talking, please, about the legal principles that are most likely to cause conflict when parties draft contracts following the language and terms of New York law, but then apply a completely different law. What legal principles would you point to, and what real-world examples can you share with us about this issue? I believe you are.
Yes, indeed. That was my thank you, and I was muted through the thank you. I apologize. I was just saying first, thank you very much for inviting me. Let me express my gratitude to you and to the organizers. It's a privilege to be on this panel. I also think our topic today is a great one because it relates to something that comes up frequently in practice. And the scenario, I think, is something like the following. The parties to an international contract, be it a share purchase agreement, a joint venture agreement, a construction contract, or something else, have lawyers in New York or London do the drafting. And the resulting document is in what I would call common law style. That is, it is lengthy, It attempts to spell out the parties' rights and obligations in great detail, and it uses terms of art that are familiar to common law practitioners. And then during the negotiations, one side gives the governing law away by agreeing to accept its counterparty's law, or by compromising on a third state's law that is perceived as being neutral. And thus the problem arises because contract drafting and the choice of the governing law are interrelated. The governing law tells you what the provisions of your contract will be understood to mean. And indeed, that's in large part the point of including a choice of law provision. And so when a contract is drafted with a particular legal system or a legal tradition in mind, and then subjected to a different governing law, clashes can arise. And maybe just to illustrate, let me tell you a little story, which unfortunately will require dating myself to some considerable extent. But in the late 1990s, when I left the Iran-US Tribunal and started working for a firm in Amsterdam, a senior associate in the corporate department came to me with a question about a contract he was drafting for a very substantial joint venture deal. And the contract was only 5 pages long, whereas the New York equivalent would easily have been north of 50. So why the difference? Well, because it was a Dutch law governed agreement, and the broad concept of good faith that imbues Dutch law will fill in the gaps. Whereas if New York law had been chosen, the associate's draft would have been a disaster, and his career would have ended doubtless on that day. So the point is simple, especially where different legal traditions are involved, the choice of law matters. So what are the legal principles that we need to bear in mind in addressing this issue? I think primarily the principle of freedom of contract that exists in nearly every modern legal system, meaning that choice of law provisions will be enforced. At the same time, courts and arbitrators will want to effectuate the party's intent and to render an outcome that they perceive as fair. And so in our scenario, we enter a sort of gray area. The party's detailed and unambiguous New York law style contract suddenly becomes uncertain when subjected to a different law. Now, in the interest of time, let me just give you 2 real world examples. First, in one of my recent cases, the parties had drafted a detailed common law style shareholders agreement for a major oil and gas project. And the contract set out rather clearly the arguably harsh results that would follow for a party who did not comply with cash calls. It's fair to say that if New York law had applied, the claim asserted by the defaulting party would almost surely have been hopeless. But the parties had chosen Dutch law to govern the contract. And under Dutch law, the rule on contract interpretation is that the words used in the contract are not decisive. Rather, the court will apply, and here I quote from the classic case on this in the Netherlands, the meaning that both parties could reasonably have given to the contractual terms under the circumstances, as well as what the parties could reasonably expect from one another. Obviously, a much more sort of broad interpretive standard. And so in that case, it became arguable that rather those plain words should in fact be read to mean something far more favorable to the defaulting party. Then second, and just very quickly, just to show it can go both ways, let me mention a construction case I'm sitting in between 2 Latin American parties concerning a project in Latin America. The parties nonetheless subjected the contract to New York law, and it contained a clause that was described as a penalty. You can imagine this immediately gave rise to problems because under New York law, actually New York public policy, penalty clauses are not enforceable. So that brings me to my very last point, which is the difficulties that can arise when New York law terms of art are used in a contract subjected to a different governing law. Just to list, and only to list a few, and maybe we'll come back to some: integration or merger clauses, consequential damages, hold harmless clauses, good faith, time is of the essence provisions, and gross negligence. These are terms that may have no meaning or at best an uncertain meaning in many civil law systems. So with that overview, let me pass the baton, Laura, back to you.
Thank you so much, Brian. And I will now turn it to Julie. Julie, Brian mentioned New York law terms of art. So at a more granular level, tell us please, how does this conflict play out when the contract uses precisely New York law terms of art that have no particular meaning or a conflicting meaning under the governing law? Over to you, Julie.
Thank you, Laura. The example that I think comes back with some frequency in my practice, and I feel like I've seen this come up really quite a number of times, is the following. So picking up on Brian's example of a negotiation and a contract that is drafted by common lawyers, and subsequently Colombian law or Chilean law is being chosen, Peruvian law, and Alfredo can speak to that. The contract is not revisited as it should, and oftentimes I think the original drafters should take the blame for this, because there may very well be an agreement to pick the local law without proper consultation with lawyers in that jurisdiction, who would probably clean up the contract if they were given an opportunity to do so. So one clause that I think is a recurring example of a switch in applicable law and the concepts don't quite translate is the key concept of equitable remedies. You see those equitable remedies clauses being used and kept in contracts that are governed by any number of civil laws. And it is simply the case that although most civil lawyers who do practice in international transactions or in disputes know very well by now what the common lawyers mean by equitable remedies, it isn't a term of art in most civil law jurisdictions. In fact, it traces back to something which is very curious about the development of the law in the UK, the split of the courts, with the courts of law giving certain remedies in damages, and if that was not satisfactory, parties could go to the king to seek relief, who the courts of the king had jurisdiction over the person, which gives us this fundamental construct that we have in common law of the damages being the remedy of choice and jurisdiction over the person and injunctions to compel a certain action or prohibit an action being secondary. Sort of absolutely fundamental concepts of the common law that really don't translate, at least not conceptually in that fashion, in the concept of equitable remedies if it is governed by a contract under civil law. Equitable remedies, equity means fairness, justice. It doesn't have an ascribed legal concept, and certainly not the legal concept that I've just explained, which is so fundamental to the construction of remedies in common law jurisdictions. Now, as tremendous a difference the concept may be, I think in practice we can't exaggerate the impact of this, because as I just mentioned, most arbitrators and lawyers find their way around this, and it doesn't create necessarily a collapse, but it will require, if the contract is given by a civil law, it will require the civil lawyers explaining well, and depending who their arbitrators are, more or less explanations are required. Many civil law jurisdictions place the performance of a contract as the remedy of choice. And we all know this is not the case in common law jurisdictions. All of these things need to be explained. And among people who do this work, people on the screen and many others joining us, this is a conversation among reasonable people that can be had, and we can all understand each other sort of above and beyond the words on the page. But to me, it's always been one of the most interesting examples, because the common lawyers drafting these contracts, a lot of them have no idea that this concept doesn't translate, that civil law jurisdictions are unitary systems of law, that they've never known the separation between the courts of law and the courts of equity. There's no such thing as this fundamental divide. And to me, that's one of the more fundamental examples that keeps coming back. I see numerous contracts with equitable remedies governed by Chilean law.
Thank you so much, Julie, for that. Alfredo, I now turn it over to you. Another area where we might see this issue arise is when the governing law has mandatory provisions that would ordinarily prevail over the terms of a contract. Can you please give us a few examples of mandatory provisions of law and tell us if, in your view, these would in fact prevail over the terms of a contract in case of conflict? You're still muted, Alfredo, so just give us 1 second. I think there we go.
Sorry. Okay, sorry. Well, thank you very much for the invitation. Conflicts usually appear when the author behind the governing law deem it important to protect certain values, taking them away from the parties, and the disposal powers and their autonomy. So these values can be related to some notions of the rule of law, but also some moral views, and the lawmaker has chosen to favor. And I will use practical examples. For example, the unilateral principles establish that the contract cannot have clauses against the provisions aimed to guarantee the rule of law and the good faith, including, for example, gross disparity. And that is what is said in Article 3.1.4 of the unilateral principles. No? The provision of fraud, treat, gross disparity, and illegality contained in this chapter are mandatory. And what happened when you have a contract that in some term disregard or do not want this principle of gross disparity apply? According to the official commentary of the principles of the unilateral principles, the provision of the chapter relating to fraud, treat, and gross disparity and illegality are of a mandatory character, and it could be contrary to good faith for the parties to exclude or modify this provision when concluding the contract. Usually, when there is an apparent gross disparity between the contract's obligation, the party agree the clauses to limit the use of this remedy. However, due to the mandatory norms that require the application of the legal institution, this agreement to be contrary will not be valid. And this kind of provision that you find in the unilateral principle is very common around civil codes in European countries, Latin American countries, Asian countries, etc. Second example, and things can be even more complex. There is a huge discussion at least in Latin America and in Europe, if good faith is a mandatory principle. Can you have an agreement against good faith or not? Can you say that good faith is not going to be applied in this or in these circumstances? I had a case of a contract subject to common law principles where the parties agree that good faith is not applicable to certain issues. They say expressly, good faith and any good faith principle is not applicable. A decision that considers that good faith is not applicable according to the contract will be enforceable by a Latin American country or Latin American court facing a civil code that recognizes good faith as a legal principle. And a final example. Under Peruvian law, and this is also a real case, under Peruvian law, the parties are not allowed to agree to a lease for more than 10 years. There was a contract subject to a new law that established a term longer than 10 years. The reason of this limit is that the term of the lease contract will be to prevent the right of the use of property owner from being limited for a long time and allow the property to be transferred to its heirs or to anybody. New law does not set a maximum term for the lease of this kind. So is that provision enforceable or a decision in that contract enforceable under Peruvian law? And are you going to have a problem if you do not take in account that it is a mandatory provision under Peruvian law? So say that I return the floor to Laura.
Thanks so much, Alfredo. And I turn it back to Julie. Julie, we would be interested in knowing your views on this question of how to handle a potential conflict between mandatory provisions of law and the applicable terms of a contract.
Okay. So mandatory rules is the topic which almost was the subject of my PhD dissertation way back when. And it is a topic that I have found of the utmost interest throughout my career. I'm holding this here. I don't know if people can see it. The camera switches like a mirror, so you can't read. But it's a book titled "Mandatory Rules in International Arbitration" by George Berman and Lucas Mistelis. They are editors of this collection, and many practitioners whom we know well have contributed to this book. And the literature on mandatory rules in international arbitration is really quite simply fascinating. I think one comment that we must point out from the get-go is that there's really two ways of looking at mandatory rules. One is, and this is perhaps the most commonly known definition of mandatory rules, and that refers to circumstances where the parties cannot contract out of a certain rule of law. And whatever they do, whatever the contract says, whether they address it or they don't address it, they really can't change the applicable rule of decision. And antitrust is something that comes to mind. There are many other topics you can't contract your way around, sanctions, various matters that we refer to most commonly as public policy in common law jurisdictions. And public policy is a term that is much more commonly used in common law jurisdictions, whereas mandatory rules, I think, finds its way much more easily in the lingo in civil law jurisdictions. But that is really just one of two definitions that we can use for mandatory rules. The other one is more of a conflict of laws approach to the definition. And it's broader in that sense, because what it is you can have a given applicable law to your contract. But if there are mandatory provisions of another law, it will not matter that you've specified New York law if European competition law principles apply because there are anti-competitive effects on the European market. Those principles will apply to the relationship between the parties. And there's, as we just discussed, nothing that the parties can do about that. And there's nothing that New York law can do about that either, even if you specified New York law. So in that sense, it's a much broader conflict of law principle. And where we end up in some discussions is whether countries, in my example, whether New York law will recognize for enforcement purposes down the road this mandatory application of a foreign law. And reasonable people may disagree about these things. That there's various sort of shades of gray on the spectrum of mandatory laws, some of which are uncontroversial in being of a mandatory application, and others perhaps more questionable, at least because they vary from jurisdiction to one another, will give rise to different perspectives. And the last thing I would say, and that's always interesting, is there's various pieces of legislation where the exercise in determining what is mandatory and what isn't necessarily obvious. I think we've all been through this, whether it's provisions of various pieces of legislation, including the Federal Arbitration Act, or even the ICC rules in some circumstances. And I think that there are any number of sets of rules where the mandatory nature or gap-filling nature is something that needs to be assessed. And the civil lawyers, by and large, as a community, are perhaps more used to the gap-filling function of legislative rules than the common lawyers, where the tendency, and it's easy to oversimplify in this area, but there might be more of a tendency to say if it's not mandatory, then you can do whatever you want. But the gap-filling function can be quite significant, and civil lawyers are quite adept at seeing these distinctions overall.
Couldn't agree more, Julie, thank you. Galena, I want to bring you into the fray now. How might the conflict between the parties' contract and governing law play out differently if the conflict concerns procedural matters? And please consider not only the law governing the contract, but also the law governing the arbitration agreements or the lex arbitre in your answer. Thanks, Galena, over to you.
Thank you, Laura. Thank you for the question. And in general, thank you to the organizers for the invitation to take part in this conference. Well, the question as you formulated it obviously makes me think about the arbitration agreement. and most importantly about the rules which govern the interpretation and validity of the arbitration agreement. So what is the law governing the arbitration agreement? As we know, in practice, it's very seldom, but for practicing the contract, define the law which will be governing the arbitration agreement. But even if it is defined, this law governing the arbitration agreement may come in clashes with some other sets of law. And when the law governing the arbitration agreement is not determined, then we have a choice between the law governing the contract as such from one side, and from another side, the lex arbitri, like the law at the seat of arbitration. So if one country is, like again, I take Latvia, for example, the governing law, but the seat of arbitration is New York. So what kind of governing law will be applicable to the to our arbitration agreement? And of course, this will predetermine a lot, including whether the dispute can be arbitrated at all. So here we come, so what is the arbitration agreement? Is it a substantive agreement, or this is a procedural agreement? So already, depending on which law you apply, you may come to a different conclusion. In most civil law systems, I think we civil lawyers will come to a conclusion that this is a procedural agreement. Therefore, we will follow in several cases, maybe not all of them, will depend on the circumstances, in applying the rules of procedure of the lex arbitri, of the seat of arbitration. Now, let's think about arbitrability. So the law of the governing, a law of a contract, says the disputes involving states and state entities cannot be arbitrated. And yet we have a Latvian party which is subject to the arbitration proceeding in New York. And by the way, the Latvian law says this, the states and state entities cannot be party to the arbitration agreement. Yet we all know that, Latvia is also a party to some exit proceedings, arbitration proceedings, not to mention some other cases. Another example is, the governing law of the country says, the disputes involving immovable property generally, just not specified, are not arbitrable. Or there are laws which say copyright law disputes are not arbitrable. Or another example, for example, when a party to the dispute is a bankrupt party or is subject to the ongoing bankruptcy proceedings. So it is not declared bankrupt yet, but it is only a party to the ongoing proceedings. So, which law to govern the arbitration agreement? I presume, and I'm not an expert in New York law, but the examples which I mentioned, there are no limitations pursuant to the New York law to the arbitrability of this kind of disputes, right? So which party's position do you take? Is it the governing law of the contract, which governs the agreement? Here we proceed to arbitration, or the law of the seat of arbitration. So these situations, I wouldn't say that they arise in practice regularly. So we are happy, lucky in this respect, but at the same time, they arise regularly, and then it's a matter of how you interpret the law, how you interpret which rules of interpretation you apply. It's interesting, I was listening to Brian, again, for me, the logical way of interpreting the provision would be the literal meaning, the language used by the contract. I would look at the general context of the contract, and I will definitely look at the intent of the parties. But again, the rules of interpretation might differ from jurisdiction to jurisdiction, and this will lead obviously to a different result. Thank you, Laura. I pass it back to you.
Wonderful. Thank you so much, Galena. And I am now going to pass it once again to Julie. Julie, you've referenced in your prior sort of answers differences between common and civil law. And if we may go back to that point and ask you to sort of further elaborate on potential conflicts precisely between common and civil law principles, considering, for instance, how well do common law terms and principles translate into civil law systems, and what are the sort of typical conflicts that are prone to arise?
A little bit of background here. I grew up in Canada, which is a bi-juridical country where Quebec is, for at least private law matters, a civil law jurisdiction, and the rest of the country is common law, following the common law tradition. And we also have a country which speaks two languages in an official manner, French and English, English and French. There are, as a result, innovative legal endeavors that have arisen from this bi-juridical nature of the country and its bilingual nature as well. I'm referring to extensive attempts that were made to translate the common law terminology in French. And in many instances, this has led, because there was no immediate counterpart to some of these concepts, to inventing French words for that purpose. There are 2 universities in Canada that teach the common law in French. The university I went to teaches both common law and civil law, as do other universities in Canada. The way McGill in Montreal does it is interesting in that the program has changed over time. When I did it, I did my first year in civil law, contracts, contrat, obligation, and so on. And the second year switched everything, the same topics we acquired the same topics in common law. The way this program has been modified and has been done and delivered for some years now is really simultaneous. So the same professor is handling both the common law and the civil law concept, or the civil law and the common law concepts inside the same classroom. And this is quite innovative, and students go through the whole program. So to answer your question, more directly, Canada is like a lab of the topics we are discussing on this panel, with lots of people and scientists working in the lab to see what they can do in terms of translating the concepts and teaching them to generations of lawyers who ultimately will be trained in both in a very unique comparative law perspective. And it can be done, Laura. It's not perfect. Some of these French translations will make you smile, but the effort is extremely valuable, and certainly learning the 2 traditions side by side is tremendously enriching, similar to learning 2 languages at the same time. And the comparison has been drawn many times to the students essentially really being bilingual in 2 legal traditions because of their training.
Thank you so much for sharing that very interesting background, Julie. And Alfredo, why don't we do the same with you? You obviously come from Peru and can give us your perspective on this issue between common and civil law from a Latin American perspective, please.
Yes, in the past, it is common that courts, mainly in Latin America, resisted to apply common law or legal institution as they are not recognized expressly in national law. And they talk and there are some articles in the 90s or the 80s or the 90s talking about the invasion of the gringo law, or some sort of imperialism, of legal imperialism came in to take our law and changing it. But that I have the impression that is changing. That is changing, and that has changed in an important way in the last few years. Recent years, there has been a certain openness to accept the inclusion of common law legal institutions in Latin American legal systems, mainly thanks to international transaction and the growth of commercial interaction. Different laws at the same time are in competition with each other. And consumers, merchants, and law practitioners in this market are all the time choosing of diverse supply options. And the idea of a legal system as an organized body of logical and consistent set of rules is not true. In the international arena, law is more than a product of a spontaneous order, where you have an organization that came from the general use of different agents that began to use it, and they began to make it more popular and popular. And in that way, that explains in some way the success of New York law. That came mainly from the fact that consumers are choosing that law. And one of the reasons they are choosing that law is because, I understand, it's a law that mainly protects the autonomy of the parties. They respect a lot what the contract is saying. But this competition is also expressed in the terms of conditions that are included in the different contracts, regardless of the applicable law. The use of common law clauses and terms in Latin America contracts is turning more and more frequent through this spontaneous order process. For example, the use of parallel evidence rule, the four corners rule, included in the terms of the contract that change in a way how you interpret the contract. And they are now very common, very, very common. And you get to read where these come, and they are not regulated as such in any civil code, but they are of very common use. Another expression of this application of common law doctrines to the application of general principles as good faith or actus proprius, estoppel, or abuse of rights, they open the door to common law principles that are applied. And I will give you a case, and I will finish with this. There is a case in Argentina. It's a very simple case. Aníbal Dominella, he hired a restaurant to have a lunch for his daughter's wedding. The wedding was frustrated, and he asked to collect the money. He said, "Turn me the money. There was no wedding," and there is no provision in the civil code at that time in Argentina for the frustration of the purpose of the contract. But the court applied the same principle using good faith. They applied the same principle using good faith. And there are some cases. Peru, I've had a case in arbitration related to a delivery of a soap opera program that have more or less the same, and they say this is impossible, but finally the tribunal find that it's a case of frustration of purpose, use good faith, and quote British cases to support that is an applicable international principle, and they apply. And for example, in Argentina, they changed the civil code in 2014, and they include frustration of purpose as a rule. So you can see that this competition is all the time working, and I think that if we have more commerce, more interaction, that this process is going to be more deep and deep, and I would say that laws will begin to look more alike, like Coca-Cola and Pepsi with the time.
Absolutely, thank you, Alfredo. Let's transition now to talk about the tools that are available to arbitrators to resolve conflicts between the parties' agreements and the governing law. And so I turn it over to you, Galena. May arbitrators resort to international principles such as unidroit, for instance, to resolve a conflict between the contract and its governing law, and vice versa? May arbitrators resort to domestic laws to resolve a conflict between the contract and, say, unidroit principles? If so, when? Please, Galena, to you.
Thank you, Laura. I know I have to answer your question, but I just take 30 seconds to add to what has been said before. Several years ago, when I joined the faculty of the University of Versailles, and I'm the only foreigner there, it was interesting for me because the faculty asked me to teach common law. This came as a surprise to me, but then I started to think about, why did they ask me? This is a public French university, yet they recognize that there is a need to the students to understand a different legal system. The reality is that both systems are used in the world right now. So if you want to practice contract law later on, at least you have to have basic notions, right? So this is interesting, how the different system of law permeates the opposite system of law, right? And there's an eventual convergence, as Alfredo has said. And now to your question, whether the arbitral tribunals can use unidroit principles. And of course, they can use, and probably in some cases, I should say, they should use the unidroit principles, which are now in the fourth version. This is the latest version is 2016, providing the preamble for 5 situations in which unidroit principles can be applied. So one situation, obviously, is when the parties to the contract provide for the application of unidroit principles. So this is not a scenario which we discuss here. But another scenario provided by the unidroit principle is that the tribunal or the court, because it's it's not addressed exclusively to the national judiciary or the arbitration specialists. So the principles say that they may be used to interpret and supplement domestic law. So the unidroit principles, they say openly, like you have to apply this principle, you may apply this principles in order to supplement and interpret domestic law. So there is like, so to say, voie direct, like direct route how to apply UNIDROIT principles. But then, like when you think about it, there's also indirect way how to arrive at the same conclusion. So let's assume, like you have an arbitration seated in New York, but yet this arbitration is conducted pursuant to ICC rules of arbitration. So we have a rule in the ICC rules, which you will find, similar rule in many other rules, which states the arbitral tribunal shall take into account the provisions of a contract, if any, between the parties and any of the relevant trade usages. So any relevant trade usages, again, here we come to the UNIDROIT principle, first of all, right? There might be other usages of which the tribunals might think, but this is, UNIDROIT principles is a good compilation of what is considered to be principles now recognized and admitted in many jurisdictions worldwide. So yes, the UNIDROIT principles may be used and should be used as a benchmark for principles now in force and for interpretation of the national laws. I was in preparing this this talk, and I had another recent talk about UNIDROIT principles. I was looking for more materials, and there is an interesting document prepared 4 years ago as well in 2016 by the IBA working group on the practice of UNIDROIT principles, and it's called Perspectives in Practice of UNIDROIT Principles. And there are interesting sections going by jurisdiction. So there is also a section on US. And it's interesting, like when we try to apply the UNIDROIT principle, we have to be clear. When the domestic law gives you a clear solution to a problem, UNIDROIT principles are not applicable. Like there is no space to apply them. Like you have a domestic law provision which gives you a direct answer. But when not, again, the UNIDROIT principles cannot be applied in all the circumstances, in all possible scenarios, because again, some concepts are not equal in one system of law and another system of law. So pursuant to the, to these perspectives published by the IBI working group, for example, specific performance, liability for conduct during the contractual negotiations, unforeseen circumstances. These are not concepts known to, I don't know, like American New York law restatement, like you take whatever, but yet they are incorporated into the UNIDROIT principles. So there is a mismatch between two systems. So you have to understand when you can rely on them, when you can invoke them, and when there will be an abuse or improper use of those principles. And sometimes we also understand that, again, the principles don't provide solution for all possible scenarios. So sometimes we have to go and to see what the domestic law says in one or on one of another specific issues. Like normally, like my feeling is normally there's little application for the national law if the parties have already contracted out the national law. But perhaps in certain cases, you can look at the possible applicable national laws and to see whether there are synergies in the provisions relevant for the dispute, and then make a final decision based on this, like on your consideration, what are the spread and accepted practices in particular domain. Thank you.
Absolutely. Thank you so much, Galena. Julie, very briefly, can you just share your views on whether arbitrators can and should, in fact, resort to UNIDROIT principles to resolve this kind of issue?
Let me offer a contrarian view and simply begin by being reminded, as we should, remind ourselves of what the project was initially, where a number of extremely prominent law professors around the world sought to bridge the gap, and I was fortunate to be close to several of them in the years when I was either in law school or subsequently myself considering an academic career. And it is an academic project. The reality, in my view, and this is where I will express a contrarian view, is as beautiful as the project is, it has limited application. And although it makes sense if the parties have agreed to designate UNIDROIT as the rule of decision for their contract, of course, then it should be applied by the arbitrators. Outside of that, whenever there is a governing law, which is the situation of most international transactions, unless the domestic law somehow would accept the application of the unidroit principles in addition to its own law or as part of its own law, I fail to see really how the unidroit principles would ultimately provide a basis for a decision, that they may be looked at, that they may be discussed, that they may be contrasted with the applicable law. This is all obviously fair game in that all arbitrations are intellectual exercises in which we debate the scope of rights and obligations of the parties, looking at various instruments. Many of them are soft law based as well. But ultimately, I think we have to go back to first principles. The predictability of commercial contracts is key. Many corporate lawyers who draft contracts every day may not even have heard of the unidroit principles. They may not even know what they are. They certainly most likely have never looked at them, even if they sort of vaguely heard of them. And very few corporate lawyers would venture to select the unidroit principles as the governing body of rules for the contract. So I think in that sense, I have to give perhaps a little bit more of a negative view. I think the unidroit drafters sort of went out a little bit on a limb in suggesting that they could have the unidroit principles apply outside of the outside of the choice made by the parties. I think the choice of the parties is really what governs everything in that area.
Laura, if I may just for a second, I really appreciated your answer. And I found a case, interestingly, this was a case decided in Stockholm back in 2002. And two parties were, one party from the United States, another party was from Russia. And there was a dissenting opinion. So let me cite what this dissenting opinion said, like one sentence, which very much goes along the discussion we have here. So he says, okay, we have a different understanding, and then he said, like, the laws of the Russian Federation and the state of New York have to be considered together. The unidroit principles are widely considered as solid guidelines of international quality, or sometimes even as the reflection of international trade usages concerning appropriate contracts. So exactly like as we have a discussion here, there was a majority which took a decision that, like unidroit principles were not applicable at all or relevant at all. And one of the arbitrators considered they might be of some use. So this is an ongoing discussion.
Without a doubt, and a fascinating one as well. So thank you so much, Julie and Galena. Alfredo, in one of Julie's previous questions, I believe she referred to public policy. And so let's consider what other factors arbitrators can consider when confronted with the issues that we're discussing today. Tell us again, Alfredo, in your views, should arbitrators have regard to public policy when resolving conflicts between the terms of a contract and governing law? Alfredo, sorry. Apologies that we're having a bit of a technical glitch. There you go, please.
Sorry. Okay. Public policy is another important source to decide whether the governing law should prevail over what has been already agreed in the contract. The official commentary of Article 1.4 of the unidroit principles established that the principles do not restrict the application of mandatory rules, distinguish between rules arising for a specific regulation from those which arise from the public policy consideration. And I will only read the relevant part of the commentary. And they said, however, in the various national legal system, restrictions of freedom of contract may also derive from general principles of public policy, whether of national, international, or supranational origin. For example, prohibition of commission of indictment of crime, prohibition of corruption or collusive bidding, protection of human dignity, prohibition of discrimination on the basis of gender, race, religion, prohibition of undue restraint of trade, etc. So, according to this article, mandatory is one thing, public policy is another thing, but they have more or less the same effect. And the problem with public policy is that it is not clearly defined. And we have all this discussion about international public policy, domestic public policy, etc. If the governing law has public policy principle, which clash with the agreed clauses of the contract, the former should prevail over the latter. That's the main principle. It is important to take this into account, not just because the importance of the public policy per se, but also because the implementation it may have regarding the recognition or enforcement of an international award. As you remember, as you know, according to the New York Convention, one of the causes to recognize the enforcement of an award is that the subject matter of the difference is not capable of settlement by arbitration, and the recognition of enforcement of the award will be contrary to the public policy of that country. So public policy has a real effect, not only according to the governing law, but also because of the enforcement of an award.
Thank you so much, Alfredo. And Brian, we are eager to hear from you again. So please tell us your views on whether or not arbitrators can have regard to public policy to resolve the issues we're discussing today.
Sure, thank you very much. I'll just add a few thoughts from a New York perspective. The first point, which I think I mentioned earlier, is that New York law, like the law of most jurisdictions, will enforce choice of law provisions in a contract absent unusual circumstances. So you will get that, even in the situation we've talked about where it may create difficulties. And the circumstances where that won't happen are essentially, at least as a matter of New York law, the existence of a contract defense to the clause, so fraud, duress, unconscionability, or the like, or that the choice of law clause violates public policy. Now, public policy, at least as understood in New York, has a relatively narrow meaning in this context. As described by the New York Court of Appeals, it is limited to, and I quote, some fundamental principle of justice, some prevalent conception of good morals, some deep-rooted tradition of the commonweal, which is a great term. So with that in mind, let us ask, when might public policy intervene to override what the parties have agreed in a contract as construed under the governing law? And let me just mention 4 possible examples. The first is an obvious one, that's bribery or corruption. It's well settled in New York law that courts or arbitrators may decline to enforce a contract that is tainted by corruption. And indeed, following up on what Alberto said, that prohibition forms part of international public policy as well. And you'll all recall the famous World Duty Free against Kenya arbitration. Next, as Julia's mentioned, antitrust or competition law, which, as you know, forms part of public policy in the EU member states. And to give a sort of example in practice, in a case I handled while still at Freshfields, the respondent, which was a large pharmaceutical company, had allegedly sublicensed IP rights in violation of a contract clause in the underlying license agreement. And the company argued that the licensor had refused consent because the sublicensee was its biggest competitor, so for a bad reason. And the tribunal indeed agreed that a refusal of consent to the sublicense based on a desire to stifle competition would not be given effect. Now, thirdly, let me just mention due process is a public policy imperative. And on this score, it probably suffices to remind you of the Pemex case, where the New York federal courts refused to recognize a Mexican court judgment, setting aside an arbitral award, thereby bringing an award of about $400 million back to life on the ground that the Mexican court judgment setting it aside was repugnant to, and I quote, fundamental notions of what is decent and just in the United States, so public policy. And then finally, let me just mention environmental protection, which in my experience is being invoked in more and more cases, particularly investment cases. So those are just a few examples of when it may intervene. With those short examples, let me hand the floor back to Laura with thanks.
Thank you so much for that, Brian. Alfredo, there are authors who argue that the competitiveness of New York law and the reason behind why parties may choose New York law to craft their contracts has to do with the fact that judicial precedents in the state of New York have adopted the principles of lex mercatoria. How would you define very briefly lex mercatoria, and does it have a role in resolving the problems that we are discussing today?
It is important to understand what lex mercatoria is, to understand which is its relevance, because I think it's very relevant about what we're talking. Lex mercatoria is not some kind of divine law created by God and is in some place and we're looking into the clouds trying to find it. The lex mercatoria is created by the people. It's created by the people through their interaction. And the lex mercatoria is made by the clauses that the parties create to address specific circumstances of the time and place in which they celebrate a contract. And the repetition of this kind of agreements turns to be and use and a practice that turns to be a rule, finally a rule that the parties understand, even if it is not written in any place directly. For example, Elsin mentioned that the decision maker applying lex mercatoria really utilize those articulated rules through the cooperation of the parties on the basis of the principle of freedom of contract and pacta sunt servanda and procedural safeguards. This process, however, is guided by a trial and error method. Parties design clauses which think will be best suited for their problems. And if those clauses are economic efficient and practical effective to solve a problem, they will tend to replicate in other contracts by imitation. Cut and paste is the main source of lex mercatoria. Copying one contract and repeating a clause that suddenly becomes common use is how lex mercatoria is created. So terms and conditions are created more than through one individual brain. They're created through a source of collective brain. And it has a very practical effect in terms of how it is created. This form of competition, this really against competition, is very relevant. Maybe it is more relevant than, and I disagree with Julie, more relevant than the choice of the governing law. At the time in the ICC, mentioned some statistics that I found very interesting. Statistic, only 30% of the cases of the awards decided under the ICC rules, the law chosen by the parties was quoted in a relevant way to support the decision. In 70% of the cases, the arbitrators quote the contract as the main basis. They use the contract. They go to the relevant law in only 1/3 of the cases because they are looking at the contract. And when I said they look it in a relevant way, is because they are using that in a way that is needed to solve the case. And usually arbitrators use the contract to solve the case. And that is because they find that the contract is expression of this process of competition of clauses. And if parties choose that, they have to be respected in their choice. So lex mercatoria develops in a process of a kind of natural selection, and the survivors are compiled by various institutions. I don't think that UNCITRAL is lex mercatoria. UNCITRAL is an effort to compilate lex mercatoria, to try to understand which these principles are, but these principles are changing all the time. So as natural selection, lex mercatoria is a process of mutation and adaptation to circumstances. And it's happening all the time. The process that we described of Latin America jurisdictions transforming common law principles into civil law principles is an example. They are changing that because of the practice. So Bruce Benson is an excellent book I recommend to read. The Enterprise of Law explains this process in a very clear way. He even explained why one of the reasons of New York's success is because they began to copy lex mercatoria. They began to use the principles, and they began to use these principles even over the common classical principles of contracts. And because of this use, and mainly this use means you have to respect the parties. You have to respect, you only can change what the parties have agreed in very exceptional cases. You don't have the power only in exceptional cases to rewrite the contract. These principles came mainly and are very consistent with what lex mercatoria is and why it is created. Thank you.
Thank you so much, Alfredo. And Galena, just very briefly, you're obviously, your home jurisdiction is Latvia, you now live in Paris. Julie was telling us about sort of the role and interaction between French and English, for instance, in Montreal. What unique challenges would you say do arbitrators face when the governing law is not in the same language as the contract, and how, if at all, does this affect the conflicts that arise?
This is an issue I come regularly which I encounter regularly in my practice, is I believe also the case, especially with Alfredo and Julie, because most of the contracts on the basis of which dispute arise and come before me, they actually are drafted in English, not all of them, but a good part of them. Yet the applicable law, sometimes it will be English, sometimes it will be Cypriot, like I had a case with Indian law, but in other cases, it's very often, like other Central European countries law or French law or Spanish law. So we don't have a priori, like the legislation which was drafted in English. So what happens in practice? The parties obviously submit to the arbitrators translations. Very often, I think the case is that, at least in my part of the world, there is some sort of a state language translation agency, right? So on the website of that state and agency, you will find translation of many legislative acts, and especially like very important legislative acts, like all the codes normally would be there, laws on privatization, laws on competition, and so on and so forth. And then you will get that translation before you, and as an arbitrator, you start to read it and you understand, like it doesn't read well. It doesn't read well, as simple as that. So you try to understand what is meant by this. I think what helps, obviously, is if arbitrator, like is a native speaker or is fluent in the language in which the legislation was drafted, then obviously you have a benefit of reading the original. If you don't have any notion of, like if you're not fluent in that language, perhaps you come from a similar background, like, so for example, like I don't read Estonian because, like probably I will understand some Lithuanian if I have to read, but not Estonian, which is closer to Finnish. But then the concept and how the law was, has developed, like if we go back to the Soviet, beginnings, and then how all the European Union laws came in and how they were implemented in the country, then you understand the logic behind it. So, like sometimes I think like arbitrators are left with the task of perfectioning the translation of the core provisions of the applicable law. And I find sometimes it's difficult, like to ask the parties, provide me a different translation. So you are fine, like you find yourself in a situation when you have to really to crack the translation and to make it workable. But this is a state of life, like, so you just have to deal with it.
Indeed. Thank you, Galena. And that's a nice transition and segue into sort of the last topic that we're going to be discussing today. And that is, let's consider this problem specifically from the perspective of the arbitration practitioner. And so a specific question on that to Brian is, how should practitioners finding themselves in a situation where the contract was, as we've been discussing, drafted in accordance with New York law principles, but a different governing law applies? How should practitioners take this into account in their arbitration selection strategy?
Well, thank you very much, Laura, for the chance to address that. I think the beginnings of an answer to the question have emerged from our conversation today. Contracts drafted with one legal tradition in mind or a different law in mind and then subjected to another raise difficult issues and the potential for surprise victory or surprise loss on one side or the other. So the choice of the arbitrators, which is in all cases one of the most important strategic choices that a party makes in an arbitration, becomes even more critical in this context. So let's start with a party-nominated arbitrator, the wing. In the scenario that we are discussing today, I think you want to identify candidates who are experienced in the types of issues that arise where there is a drafting governing law disparity and have experience in both of the legal systems implicated by that disparity. So for example, if it's a New York law form of contract then subjected to, let's say, Dutch law, you will probably want someone who has seen cases like that before, who is either a New York or a Dutch lawyer, and who has substantial experience with both sides of the common law, civil law divide. And of course, as in every case, you'll want candidates who are well respected in the field and thus likely to be listened to by the presiding arbitrator. So how will you identify those people? Well, through the usual due diligence process. You'll read any of the candidates' awards that are publicly available. You'll talk to your partners and colleagues at other firms who have sat with or appeared before the candidates on your list. And you will read, or more likely have some poor junior associate read, everything potentially relevant that the candidates have published. And then after you have your short list, it's a matter of refinement. So in the New York Forum Dutch law example that I mentioned, the question may come down to how you want the contract to be interpreted. If your client's interests are best served by a plain reading of the contractual language, you probably want to select a US or potentially a UK Commonwealth candidate. But conversely, if you prefer a more good faith infused construction, go for a Dutch or other civil lawyer. But in both instances, someone who straddles the common law civil law divide. To give you a quick example, in the oil and gas shareholders agreement case that I mentioned earlier, oil and gas that I mentioned earlier, which was in fact a New York law style Dutch law governed contract, the claimant, which preferred a liberal interpretation, a forgiving interpretation, appointed a well-respected Dutch professor, and the respondent, apparently preferring more of a plain meaning, appointed a US arbitrator who nonetheless had substantial Dutch law experience. Now, what about the presiding arbitrator? Just to conclude very briefly, again, the same dynamic will be important. You likely do not want someone who is perceived as firmly in either the strict interpretation or the liberal interpretation camps. And I would think someone with a reputation for practical, commercially minded decisions. Beyond that, with respect to the chair, you of course want to look for the characteristics that are always desirable. Someone who's smart, experienced as a chair, and has a demonstrated ability to manage an arbitration fairly and efficiently. And given today's discussions, if my colleagues will forgive me, I would say you might look to one of my colleagues on the panel in that circumstance. So thank you very much, Laura.
I think you read all of our minds, Brian. Thank you so much for those very useful guidelines and precisely for that point. We are running a bit short on time, but Galena, I believe you wanted to share perhaps some additional advice to counsel, and then we've received several very interesting questions from our audience, and we'll sort of perhaps have time for one or two of those questions. But before that, Galena.
Yeah, thank you, Laura. I will be very brief because there is little to add what Brian has already eloquently described to us, and I fully agree with what he has said, including on the last point, right? But about starting the background of arbitrators, I fully agree on this, like that, like to look for decisions the arbitrators has rendered in the past, it is important. What we also have to bear in mind here, like given all the like trends for more transparency in arbitration, more and more decisions will be circulating on the market, like we have to remember the ICC's now policy to publish the arbitral awards after 2 years of the completion of the arbitration, provided that everybody agrees that there are no confidentiality requirements. So there will be more available background to this. At the same time, I think we also have to be cautious, and not to assume automatically that if in a string of cases the arbitrator has decided a particular way, like in favor of application of one governing law, of a specific application of a specific concept, that he or she will necessarily do the same in another case, because at the end of the case, every case is fact specific, right? So this will really depend what are the circumstances of this particular case. So I think I will also finish my presentation here, and perhaps like we still have 6 minutes for the discussion.
Yes, thank you so much, Galena. As I said, we've had a ton of very interesting questions come in. Obviously, as we said from the outset, this is an ongoing and fascinating discussion. Let me open it up to the panelists and see who would like to answer the following question. Can arbitral tribunals apply a conflict of law analysis to determine arbitrability? Is there any takers on the question?
Well, I raised this topic. Oh, Brian, go ahead.
No, please. It's a hard question, so you go ahead.
It is a hard question. I'm, I was put in a situation when I, as a member of a tribunal, had to decide on this matter. This was not the proposition of the parties to go by the conflicts of law rules, and the matter was very extensively debated. Like on the spot, I probably would see there is no necessity, because I would go by the different path of analysis, but maybe, for me, it would require further thinking and research. It's not a very exhaustive answer. I'm sorry for that. I'm cautious in this regard, but this was not my experience, at least so far.
Oh, that's very helpful. Thank you, Galena. Julie, did you want to add something?
It depends where the question comes from. Where is the arbitrability question coming from? Is it that the law governing the contract provides a question as to whether the subject matter of the arbitration is arbitrable, or it comes from a law outside of the governing law of the contract? What does the governing law say? And this goes back to also our conversation earlier with respect to the potential application, overriding application of mandatory rules. And as I pointed out earlier, this is always a function, it's like a two-way street. It's always a function of one country's laws saying that they apply, and they don't care that anything else might come into application. The nature of mandatory rules is to claim application, come what may. But then the tribunals that are entrusted with rendering a decision also have to consider, obviously, the law governing the contract, and ultimately where the contract and the decision rendered by the arbitrators may need to be enforced. So I agree with Galena in the sense that these decisions are not necessarily straightforward, and reasonable people disagree about how strictly they will follow a conflict of laws analysis, particularly given the discretion that many would ascribe to these decisions for arbitrators. But there is a legal process, there is a logic, there is there's a legal analysis that can be performed to break these things down, see where they come from, and what the relevant laws have to say about them.
That was extremely useful. Thank you so much, Julie. And I think one last question, just very briefly, in case any of our panelists would like to comment. Does the doctrine of commercial common sense as an aid to contract interpretation receive similar weight in common and civil law countries, and how much should arbitrators be resorting to commercial common sense?
I wasn't sure if I had misheard. I was like, what doctrine did Laura refer to? You said, oh, it's the doctrine of common sense. I was looking for a legal concept.
Commercial common sense is the way our question has been drafted.
Yeah, a commercially reasonable interpretation. Makes sense.
Exactly.
Yeah, and there is a mention of common sense in the usual principle for integration of contracts. And yeah, it's not commercial, but it's a common sense. And I think that it makes sense if you take, it makes common sense if you understand that the rules are created by the people who are acting, and the people are acting, merchants, they are acting usually using common sense. So what really I think that principle means is that you have to be reasonable, and reasonable have different expressions. One is common sense. Good faith can be also a way of defining something reasonable. So I think that is in the basis of the whole thing that we have been discussing. Usually the rules try to be reasonable, and usually the law, the options, the contracts try. Sometimes they do not achieve that goal, but sometimes they try to be reasonable. And I think that common sense should be used in understanding the contracts and understanding how the rules have to be applied.
Thank you so much, Alfredo, for that. And we are actually right on time, but Galena, maybe if you just want, I think, maybe add something we haven't seconds.
Very briefly, I agree with what Alfredo said. And Alfredo, both you and I, we are members of the ICC court. I was counsel there before, so we come across a lot of draft awards in the process of scrutiny. And indeed, at least like in my practice, I have seen, well, a good number of awards where indeed the arbitrators do say it was reasonable in the circumstances, it is reasonable to assume, it was reasonable behavior on the part of one or another party. So it is, you know, like these are mentioned, so it should be reasonable and we should treat them accordingly.
Thank you so much, Galena. And thank you really to all of our amazing panelists. We have a very on-point comment from one member of the audience that says that your brilliant contributions provided so much content that they're looking forward to watching the recording so that they can actually absorb all of the very interesting points and discussions. So thank you so much again to the organizers and to our brilliant panelists for this enlightening discussion. Without a doubt, a lot of food for thought. So thank you again, and also to everybody that has joined us today. Have a lovely rest of the day. We hope that you continue to enjoy New York Arbitration Week, and just thanks and goodbye, everyone.
Thanks, everyone.
Many thanks.
Thank you, Laura. Thank you, everyone. Bye.